How to prove liability in a slip and fall accident. So, by the introduction, I start by explaining that slip and fall accident can happen anywhere, from grocery stores to sidewalks, and when they do, it's important to prove liability in order to receive compensation. Liability refers to the legal responsibility of a property owner for the accident and injuries that occur in their property. Emphasize that proving liability in a slip and fall case is essential for successful claim and can be complex, but with the right steps, it's manageable. Now, the points number one is establish the property owner's duty of care. Point number one, the first step in proving liability is showing that the property owner or occur had a legal duty of care to keep their property safe for visitors. Explain that this duty is different depending on the type of visitor, like invitee, license, or trespasser. But generally, property owners are required to take reasonable steps to prevent accident. In slip and fall cases, property owner must maintain safe walkways, remove hazard, and repair dangerous condition promptly. If they fail to do this, they can be held liable for accidents that occur. Now, the second point is prove that the hazard existed. Prove that the hazard existed. So, to prove liability, you must show that a hazardous condition existed on the property that caused the slip and fall. Provide examples of common hazards such as wet floor without proper warning sign, uneven surfaces or broken sidewalks, poor lighting in walkways or stairways, spilled products or debris on the floor. Emphasize that the hazard must have been something that the property owner either knew about or should have known about. If owner didn't address the hazard in a reasonable amount of time, they may be held responsible. Now, the points number three, demonstrate that the property owner knew or should have known about the hazard. One of the key elements in proving liability is showing that the property owner either knew or should have known about the hazard. If the property owner was aware of the hazard, for example, they received a complaint from a customer. So, if the property owner was aware of the hazard, you can argue that they were negligent by failing to fix it. If the hazard had existed for a long time, if the hazard had existed for a long time or was obvious, you can argue that the property owner should have known about it and and fixed it sooner. Mention that in some cases, evidence of similar incidents or accidents in the same location may help prove that the owner was aware of the dangerous condition. Now, first point is show that the hazard caused the injury. After establishing that a hazard existed, you must prove that this specific hazard caused the fall and resulting injuries. Explain that the injury must be directly tied to the hazardous condition. Example, sleeping on a wet floor or tripping on a cracked sidewalk. Encourage the audience to gather evidence like photographs of the scene, witness statements, and medical records. These can help establish a clear connection between the fall and the injury. Now, points number fifth. Prove, prove that the property owner's negligence led to the injury. In order to prove liability, you need to show that the property owner's negligence directly caused the accident. Negligence refers to a failure to act with reasonable care. If the property owner knew about the hazard but failed to fix it or put up warnings, you can argue that their negligence led to your injury. Mention that it's essential to gather all available evidence, including witness statements, security footage, and maintenance records, to support the claim of negligence. Now, the sixth point is document everything and gather evidence. Emphasize the importance of documentation in proving liability. Every piece of evidence can help make your case stronger. Recommend each step for gathering evidence, like photographs. Take picture of the hazard, the area around the fall, and any visible injuries. Medical records. Keep detailed record of any medical treatment received. Witness statements. If there were witness to the accident, ask them to provide written or recorded statement about what happened. Maintenance records. If available, obtain records showing how often the area was cleaned or maintained. Explain that this evidence is essential for building a strong case. Consult a personal injury lawyer. While it's possible to handle a slip and fall claim on your own, it's often best to consult a personal injury lawyer who specializes in these cases. A lawyer can help gather the right evidence, negotiate with insurance companies, and represent you in court if necessary. They can also help assess whether the property owner was negligent and how best to prove liability in your case. So now conclusion is, recap the key point is, establish the property owner's duty of care, prove that a hazard existed so that the owner knew or should have known about the hazard, demonstrate the connection between the hazard and the injury, and gather evidence. Remind the audience that slip and fall cases require attention to detail, but with the right approach and documentation, liability can be proven. Encourage them to consult a personal injury lawyer to ensure that their rights are protected and that they have the best chance of a successful claim. So that's it. Thanks for watching this video.